As judgment in the appeal, the Commissioners for Her Majesty's Revenue and Customs and Pendragon plc and others.
Lord Sumption will explain the judgment of the court.
This appeal is about an elaborate and artificial scheme for avoiding value-added tax on demonstrator cars sold second-hand by car dealers. The scheme was devised by accountants KPMG and was marketed to distributors in the motor industry, including the Pendragon Group, who are said to be the largest car sales group in Europe. Demonstrator cars are bought by car dealers from manufacturers, used for test drives and other business purposes, and then sold as second-hand cars, usually after a few months. In the ordinary course, the dealer would pay VAT or input tax to the manufacturer on the wholesale price when he buys the car, and will then collect VAT or output tax from the ultimate purchaser of the second-hand vehicle when he sells it. He will then account to HM Revenue and Customs for the difference between the input tax that it has paid and the output tax that it has received. The object of KPMG's scheme was to enable the dealer to recover the input tax that it had paid to the manufacturer on the purchase of the new car, while avoiding the payment of the full output tax when it sold the car after it had finished with it. The way the scheme worked is complex and highly technical, but in very broad summary, it worked by taking advantage of the so-called margin scheme covering the sale of second-hand goods. The object of this scheme is to enable taxable businesses who sell second-hand goods to charge VAT only on the profit margin and not on the full second-hand price. The logic of this is that in the great majority of cases, the goods will already have had VAT charged on the full price of the goods when they were sold, new, and the tax should not be charged on the same goods twice. The KPMG scheme was designed to allow Pendragon to recover the full amount of the tax paid when they bought the car new and still take advantage of the margin scheme. This was achieved by passing the cars after they had been purchased through a chain of intermediaries, one of which was an offshore bank, and the rest companies controlled by Pendragon. The terms of each transfer were carefully designed to take advantage of different specific exemptions in the VAT legislation. By ingeniously combining these exemptions, the KPMG scheme sought to make use of provisions designed to ensure that tax was charged only once, in order to ensure that no net tax was charged at all, except on a small sum representing the profit margin on the ultimate sale. Tax avoidance is a difficult and controversial subject. It is traditional to distinguish between avoidance, which involves the lawful arrangement of a taxpayer's affairs so as to minimize his tax liability, and evasion, which involves the unlawful failure to account for tax which is due, usually by suppressing or falsifying information. Complicated professionally drafted schemes like this one do not fall happily into either of these categories. It is common ground on this appeal that at a purely technical level, the KPMG scheme worked. In other words, all the various statutory exemptions, if they are applied, produce the desired result, and the scheme, if given effect according to its terms, did mean that substantially no VAT tax was payable. But it did this by artificially reclassifying the successive transactions involved so as to produce a result which was consistent with the language of the legislation, but not with its purpose. To deal with such schemes, many jurisdictions, including now the United Kingdom, have introduced generalized anti-avoidance statutes. The UK statute does not deal with value-added tax. This is because value-added tax is a European Union tax, and there is an equivalent rule of European Union law to broadly the same effect. The rule is known as the abusive law principle. Its effect in relation to tax is that if a transaction or series of transactions has the primary purpose of avoiding tax in a manner that is contrary to the purpose of the legislation, the transaction or transactions may be redefined by the court so as to remove the tax advantage. The First Tier Tribunal's tax chamber held that the scheme was not abusive. They were impressed by the argument that it had a genuine commercial purpose other than the avoidance of tax. That purpose was the financing of the dealer's stock of demonstrator models by the offshore bank and the broadening of Pendragon's sources of bank finance. The Upper Tribunal overturned their decision, holding that the scheme was abusive, but the Court of Appeal restored the original decision of the First Tier Tribunal. The Supreme Court unanimously holds that the KPMG scheme was an abuse of law for reasons which are set out in a judgment which I have prepared. There can be little doubt that the use of the margin scheme in circumstances where no net charge to VAT had been suffered was contrary to the purpose of the scheme. The real question, as the courts below perceived, was whether these transactions had any real commercial justification other than the avoidance of tax. The Supreme Court accepts that there was a genuine commercial rationale for interposing the bank, and there is nothing abusive about the selection of an offshore bank. However, there were many ways in which the bank could have been interposed and the finance obtained. The particular method by which the scheme interposed the offshore bank involved complex and artificial steps, which themselves had no other purpose than the obtaining of a tax advantage. The First Tier Tribunal's failure to appreciate the significance of this point was in this court's view an error of law, which the Upper Tribunal was entitled to correct. Accordingly, the appeal must be allowed, and the transactions comprising the scheme must be redefined so as to deprive the Pendragon Group of the tax advantage which they have obtained.
Thank you for coming. Court is now adjourned.